Hey, good afternoon, everyone. Thank you all so much for joining us and spending the afternoon with us. I'm Ebony Morel. I'm the Community Engagement Manager here at Family Legal Care. Tyler?
Hi, my name is Tyler Levson. I am one of the staff attorneys here at Family Legal Care. Thank you all for being here, and I hope that the information we cover today is helpful for you. We appreciate the work and service of our military members and veterans and want to highlight some of the aspects or challenges within family law that are unique to them and that I have seen in assisting them. First, I will cover general protections for service members surrounding and during active duty service. Then I will discuss the issue of deployment and how that impacts custody. And last, I will go over how child support is calculated and collected for military members and veterans. But first, Ebony is going to provide you with an overview of what our organization, Family Legal Care, does in case you want to reach out to us later.
Thank you, Tyler. So for those of you who aren't familiar with Family Legal Care, our story goes back all the way to 1996 when a group of three young lawyers fresh out of law school realized that there was a real need for people to access basic legal information within the New York family court system. So with permission from the supervising judge in the Manhattan Family Court, they set up a folding table there in the court and set themselves up there to answer questions and offer guidance to anyone who needed some help. Today, over 29 years later, our organization has grown tremendously, but our mission remains the same. That's to increase access to justice for families involved with the New York State family court system. Today, we do this by offering parents and caregivers free legal information, advice, and resources to help them navigate the family court system in New York State. We do this through an array of different programs, a few of which I'll go over today, including our bilingual helpline, our attorney consultations, and our digital justice initiative. So the first program we'll go over is our bilingual helpline. Our helpline provides information about New York family law and family court procedure by phone, email, and live chat. Our helpline associates can also provide targeted community referrals and connect callers to our other services, including our attorney consultations. I will say though, our helpline associates are amazing and they can provide a wealth of information. So oftentimes people find that after speaking with the helpline, they have all of the information that they need to take the next steps in their case. However, if someone does need more guidance or more assistance than the helpline can provide, then the helpline associate will conduct an intake to see if the person is eligible for and interested in a consultation with one of our attorneys. And if they are, the helpline associate will go ahead and schedule the consultation then and there. Our general helpline hours are Monday through Friday from 9 a.m. to 5 p.m., although we do close for lunch from 1 to 2 p.m. every day. And the phone number for our helpline is 212-343-1122. And again, we also have the email and live chat options available on our website, which is familylegalcare.org. So at Family Legal Care, we offer limited scope representation. And what this means is that we have a team of staff and pro bono volunteer attorneys who provide free 1-hour consultations virtually, where they meet with unrepresented parents and caregivers to provide advice and guidance on their case. The support and the level of support that the attorneys will provide during these consultations really depends on the case and the litigant's needs, but some examples of what our attorneys can do include helping to draft petitions or motions for the litigant to submit to the court, advising litigants on next steps in their case, and helping litigants prepare to effectively represent themselves in court. We don't have any income or any residency requirements for any of our services. For a consultation, the only requirements are that the case is in the New York Family Court, that the litigant does not already have an attorney representing them on the case, and that the case falls under the categories of child support, custody, visitation, paternity, parentage, and some guardianship cases. We can also advise regarding orders of protection and some domestic violence issues, but only as they relate to the case types that I mentioned previously. We cannot provide consultation or advice on a standalone order of protection case. We also do not advise on divorce cases, since in New York, those are handled in the Supreme Court, not family court. And lastly, we do not advise on abuse and neglect proceedings. So if you or someone you know is interested in a consultation with a family legal care attorney, please reach out to our helpline. Again, that is 212-343-1122, or on our website, familylegalcare.org. And then the last program that I will highlight briefly is our Digital Justice Initiative, which is made up of 3 main tools: our Family Law Navigator, our guided court forms, and our Family Law Explained videos. All of these tools are designed, well, they're all available on our website, and they're all designed to be accessible using any device, whether that is a computer, a smartphone, or a tablet. And they're meant to simplify the family court process by making family law information and guidance more accessible to all. Again, you can check all of these tools out on our website, familylegalcare.org. And that's just a quick overview of the services that we provide and some of our programs. Now we're going to go ahead and dive into some of the questions that we received prior to the Instagram Live. But we do encourage you all to please plug into your questions into the chat as well. And just a quick reminder that everything that we go over today is intended to be legal information only, not legal advice. We do want you all to ask your questions, but you may hear us say that you should reach out to our helpline or speak with an experienced family law attorney. And that's just because every case is different, so what applies to one person may not apply to everyone else. And another reminder as well, this is a public forum, so while we do encourage you all to ask your questions, we ask that you do not share any personal information or details that you don't want out in a public forum. But with that, Tyler, what if we get started with discussing how someone begins a case in family court in order to get to start a case and get an order?
Yeah, thanks for going over that, Ebony. So a case begins in family court when someone called the petitioner files a petition with the court. A petition is a written document where the petitioner explains what they want and why the court should grant them that relief. The court then schedules a hearing and provides the petitioner with documents for service on the other party called the respondent.
And can you go over service? What is that? How do you serve someone?
Yeah, so this is a really important step in the process. The case really can't move forward until the respondent has been served. What that generally means is that the petitioner must have the petition that we just discussed in the summons, which is a document the court creates and lists out the information about the first hearing, where it's going to happen, the time, how to participate if it's virtual. Both those items have to be given to the respondent so that they are aware of the hearing and what is being alleged and sought in the case. It's basically a way to give them notice about the court proceeding. Generally, in-person service is required, which is where the papers are given to the respondent directly or possibly to someone in their home or work who's responsible enough to give them the papers later. Though often service by mail can be sufficient in paternity and child support cases, as long as the respondent appears later.
And what happens if someone is actively deployed or if they're staying on base? Can they be served while on base?
Yeah, they can, though it can be a bit more complicated. First, I'll start with if they're off base. Sometimes service members are living off base, and in those cases, state law rules apply just as they apply to everybody about how they can be served. But if they're on base, generally the first step in that process is that your process server, so the person who's going to deliver the papers, has to get in contact with the base and get approval from them to get access, because access is fairly restricted. Only certain people are allowed on base. And so what this access looks like will vary by military branch and the base, as there are different rules for when the military will facilitate service or make the military member available. If the base is located in another country, that host countries or international service rules might apply. And so this is where it gets kind of tricky, and sometimes you might, someone trying to serve a service member, especially in another country, might want to engage with a professional process server to navigate all of this. There are times in which alternative methods of service could be permitted, such as like via mail or email, for which a court order might be required. So that would be something you'd ask from the court to allow. But all of this makes communication with the base's legal office and the service member's commanding officer very important, so that your server is aware of what the procedure is and how to do all that.
Right, of course. So assuming that service was taken care of, or maybe it wasn't taken care of, if for whatever reason the service member does not become aware of their case in family court and they're not able to participate, what protections are available to them in that situation?
Yeah, so the primary law providing protections to military members in civil cases, which includes family court cases like paternity, parentage, child support, custody, visitation, guardianship, who are actively serving is the federal law called the Service Members Civil Relief Act. And these protections are for active duty members of the Army, Marine Corps, Navy, Air Force, Space Force, or Coast Guard. Also, people who are active service with the Public Health Service or National Oceanic and Atmospheric Administration. Also members of the National Guard who are, when they're serving in active duty status under federal orders, and also members of the reserves who are called up to active duty. Regarding family court, what this looks like there is that a service member who is actively serving could get an initial 90-day delay or stay of the proceedings, which means the case wouldn't move forward for 90 days. That does have to be requested in writing by the service member, and then subsequent stays can be requested, but they would be entered at the discretion of the judge. And it's key that they allege or show that their military service is materially affecting their ability to proceed in the case. And we can talk a little bit more about what that means in a bit. The Service Members Civil Relief Act also provides protection against default judgments or orders. So a default judgment or order is it's basically an order entered after service of process is completed, but the respondent fails to appear. It's essentially a one-sided order, or at least an order entered only with one side's evidence being considered. And so what this looks like is that the service member could get that default order vacated or undone, which would reopen the case, allowing them to present their side of the case and have the judge consider that. They can also get a stay or vacate the order of garnishment. And this means that child support garnishment could be delayed while they are actively serving and where their service is materially affecting their ability to participate in that case. And then last, there's certain circumstances in which they can get appointment of counsel to help them in these cases, such as when additional stays are not granted, they're denied. And so this is, I don't know if anyone on has seen family court petitions, but there's a section in these foreign petitions that ask about whether either party is actively serving in the military or if they've recently returned from active duty. And this is so the court knows if they should anticipate or consider these service member protections. There's actually a website called the Defense Manpower Data Center, where you can confirm whether or not the military member is active duty. And often, if there's a question of military service, this is something the court will want to see. However, this website doesn't provide information about where they're stationed, so it's not going to be helpful to the petitioner in terms of getting them served or locating where they are just to serve them. And then last with this, New York has a state level counterpart called the New York State Soldiers and Sailors Civil Relief Act, which largely mirrors this federal law. But the federal law supersedes the state level one in the event they conflict.
Great, so we heard you mention the term materially affected a few times. Can you just tell us a little bit about what that means?
Yeah, so there's no specific definition, but it requires the court to consider whether the service member can appear and prepare for hearings, comply with court orders, and communicate with their attorney while actively serving. So if they cannot, then they are eligible for these protections. Thus, there could be cases where a service member could be required to participate in a case. I know I've spoken with service members who are deployed, but they might be in an office a lot of the time and can participate in a New York State case. Or they can even start their own case while they are active duty because their service has not materially affected their ability to participate.
Awesome, thank you, Tyler. Are there any questions in the chat about anything that we've discussed so far? No? All right, well then what if we shift a little bit and start talking about custody and visitation? How are service members' rights to custody and visitation impacted by being in the military?
Yeah, so first I'll just talk about custody in general. Custody of the child involves legal and physical custody in New York. Legal custody is concerns major decision-making authority, like for healthcare, education, religion. It can be joint or sole joint legal custody. Both parents have to make these decisions together. Sole legal custody. one parent makes those decisions. And then physical custody can also be joint or sole. But sole physical or residential custody is more common in New York, with the other parent having parenting time or visitation. And that's because in New York, there is no presumption that joint physical custody is in the best interest of the child.
Can you tell us a little bit about the best interest of the child?
Yeah, so the best interest of the child is the guiding principle in custody, visitation, and also guardianship cases, and is based on the totality of the circumstances. And what that means is that a judge is going to look at a broad range of factors related to the care, safety, and health of the child, such as who has been the primary caretaker, the parent's ability to care for the child, any domestic violence history, drug, alcohol abuse, mental health issues, and the child's preference. So for service members, joining the military, going to basic training, being deployed to active duty, those all can be disruptive and challenging to a parent's relationship with their child and their ability to take care of the child. And it can also be part of that best interest analysis.
Great. So what happens if the parent with custody of the child is joining the military, or if they're already a member of the military and they're being deployed? What happens in that case?
Yeah, I mean, because it is a consideration within the best interest analysis for custody, it's often important to address custody in these scenarios. So if someone's trying to join the military and they're a single parent, which means they're not married, some branches require them to actually get a custody order or guardianship order so that somebody else technically has legal authority to take care of that child. And this can also be the case in dual military families where both parents are service members and they are both deployed at the same time. For parents who are deploying and the other is not a member of the military or is not deploying, the military will require at least a family care plan to be put in place. And in some cases, they'll require a court order. That might come up particularly where the other parent doesn't agree with the family care plan, or it seems like it's going to cause problems. And this is because family care plans are not court orders. They're not really enforceable in New York State court. A family care plan is essentially a document that lays out the arrangement for who will take care of a child and how, along with important information related to the care of the child. You know, who's this child's doctor, what is their number? And it is provided to the service member's commanding officer, the other parent, and the child's caregiver if applicable.
Are there any protections in place for parents who are deployed?
Yeah, so there are specific protections in this area, which is great. So the policy reason is that military and the law don't want the military parent service to be unnecessarily disrupted by their family life. They want them to be able to focus on their work, on their job while they are deployed. So this can be undermined when the non-military parent files for custody or to modify that arrangement in advance of or while the service member is deployed. So in addition to delaying the proceeding that we discussed about before, the Service Member Civil Relief Act also helps additionally protect the service member in this area by requiring two things. Any temporary custody order that's entered based solely on deployment, it has to expire or terminate once the service member returns. And then two, if there's already an existing custody order and the court decides to enter a final order modifying it, the return of the service member from active duty qualifies as automatic grounds to modify. And this is reflected in New York State law as well, in the Domestic Relations Law and Family Court Act. So it specifically states that where a military parent cannot act as the sole or joint custodial parent due to being materially affected by their military service, the court can modify custody if there's clear and convincing evidence that the modification is in the best interest of the child. But the court must assign an attorney for the child and has to try to provide contact or visitation between the military parent and the child during military service. And further, the return of the military parent from deployment shall be a substantial change in circumstances, which is the legal standard for modification in New York, in addition to best interest of the child. So basically what it's saying is that once they're going to put something in place during deployments so that the best interest of the child is protected. But once a service member comes back, the court will reassess things at the time. The unfortunate part is that it doesn't automatically revert back to the original order. And so you just have to see what the best interests of the child are at that time.
Awesome, thank you, Tyler. And let's say, what happens if the military member, they're the parents, they have custody and they're being deployed? What happens if they want a relative or a friend to have custody of the child during their deployment?
Yeah, this can happen at times. The service member will need to at least create a family care plan, which we mentioned above. So that would include this relative or friend in that, and they would get a copy. But in some cases, getting an actual court order will be required by the military, or it might just be the best idea to do so. That way there's an actual order in place for that person to have formal custody or guardianship. And to ensure that the service member has ordered visitation or contact with a child while they're away. They could also use a designation of person-parental relationship form for New York to give that person legal authority to make education and healthcare decisions temporarily. They could also execute a power of attorney concerning the child for those same kinds of things. But both of those technically aren't custody orders. They're limited in what they can do, so they might not be sufficient for military purposes in terms of needing an order.
Okay. Does anyone have any questions in the chat about custody, visitation, or anything that we've talked about at this point? Just a reminder, we're just going through questions that were submitted previously, but if anyone has any questions and they're here now, we invite you all to put those into the chat. But if there aren't any questions about custody, then maybe we can move into child support now. How does child support work for military members and veterans?
Yeah, so for service members, military branches have specific rules about their expectations for the service member to support their child. So when there isn't an order in place, there'll still be some expectation, probably from their commanding officer, that they support their children. And there could be possible military consequences for not doing so. The VA also, the Veterans Administrations, also expects that a portion of VA benefits will be used for dependents, children of the veteran. However, these are not court orders. They're not enforceable in New York State court in that way. And so if a formal child support order is sought, then state law will apply. And state law enforcement options might be why someone decides to formalize it into a court order. And so with state child support in New York is primarily calculated based on the parent's income and the number of children the parents have together. There is a multi-step formula in the law about how to calculate child support, which I'm not going to get into detail here. But for most cases, basic child support will be a percentage associated with the number of children, for example, 17% for one child, taken from the non-custodial parent's income. The non-custodial parent is the one who has a child less time. You'll hear me mention custodial parent later. Custodial parent is the parent who has a child more time and is the one who receives the support. And so for determining income, it can be the actual income that is earned, reflected in pay stubs, tax returns, or it can be imputed based on other information. So maybe the court says this person's underemployed, and we're going to impute income to that person based on what they made in the past or what we think they could make. There are also additional amounts on top of this basic child support obligation the court can order the non-custodial parent to contribute to, namely healthcare, childcare, and education expenses. So once that's calculated, the court can also deviate from the calculation, upward or downward, if that amount is found to be unjust or inappropriate, though it's not very common for the court to do that, unfortunately. Or fortunately, depending on what side you're on. A parent is obligated to support their child until they turn 21, or earlier emancipation, which, for example, could be the child joining the military. So often the most important consideration in calculating child support is determining the non-custodial parent's income. But service members and veterans have different types of income than civilians.
Yeah, can we talk a little bit about that? What income will the court use or consider for service members?
Yeah, so for service members, their income as provided in their leave and earnings statement, or LES, includes basic pay and allowances like BAH for housing and BAS for subsistence or food. Uh, these amounts can be impacted by custody arrangements and existing child support orders, as the military might provide an increased allowance to reflect the service member's financial obligation to their child. For example, with BAH, there are different rates, like with dependent rate, so they get more, or BAH diff rates, which is where the service member is in single quarters and paying child support. And so I've helped military members get orders to secure certain allowances. So their commanding officer says, you know, you have a custody order that says this, then you'll be eligible for this certain allowance. There has been some litigation about what counts as income for service members, but case law in New York, like in other states, holds that both basic pay and these allowances count as income. So those are included together when calculating child support in New York. So with that, if a service member is moved or relocated and receives a decreased pay or allowances, that could be a reason to file a modification petition with the court to try to decrease the child support obligation. And with modification, the court can generally modify if there's been a substantial change in circumstances, 3 years have passed, or incomes have gone up or down by 15% or more, such as relating to disability or inability to work, which can be common for service members and veterans. A modification petition should be filed as soon as possible, though, because the court typically is not going to modify child support prior to the filing date of the modification petition.
Right. And what about veterans? What income will the court use or consider for veterans?
Yeah, so the primary thing with veterans is VA benefits, and that does count towards income in calculating child support, regardless of how you became eligible to receive it. The court can also use military retirement or pension amounts to calculate child support.
Okay. And once there is a final order for child support, how is that child support paid or collected from service members?
So earlier I mentioned sometimes maybe they are not paying, there's no court order yet. The custodial parent might reach out to the commanding officer and say, hey, this person is not helping to support their child, can you help? And so there might be some movement there, some pressure to do that. But if there is a child support order, then it can be ordered to be paid directly to the custodial parent, or the service member sends the money to that person directly. Or it can be paid through the child support office, which is more common. So with that method, the primary way they collect it is through income withholding or garnishment, which is where that money is taken out of your pay. Though there are other enforcement methods that they use when the non-custodial parent falls behind or is in arrears. And so how that works then is that the child support office will send an income withholding order to the Department of Finance and Accounting Service office, or DFAS, which is essentially the employer for service members to process that garnishment. And then they will send the money to the child support office, who will then disperse it to the custodial parent. So DFAS handles those garnishment orders, and also possible communication between the other parent and the child support office. And then if the service member still isn't paying, the custodial parent might be seeking enforcement through the courts, or if the service member is the custodial parent, they could seek enforcement through court.
Great, thank you. And how does that process work for veterans?
Yeah, for veterans, it's a little bit different. There are laws protecting VA service-connected disability benefits from garnishment. So basically where like those income withholding orders can't work for that. However, there's an exception. If the veteran became eligible for the VA benefits by waiving their military retirement or pension, then the VA benefits could be garnished. So they become vulnerable. So importantly, though, even if the VA benefits are protected from garnishment, the veteran still has to pay the support pursuant to the court order. So they still are ordered to pay child support. It's just a question of whether the VA benefits can be garnished or not. And there is a separate process as well where a custodial parent can try to get support from the veteran. So if the veteran is not supporting their child and state child support enforcement efforts haven't been successful, the custodial parent can request apportionment of the benefits through the VA. So this is an administrative process through that agency where there'll be a proceeding at which the VA will decide if to apportion or send a specific amount of the VA benefits to the custodial parent for the child. And in that proceeding, they are supposed to take into consideration the financial hardship or ability of the veteran to be able to support their child, which arguably they might give more consideration to in that process than they do in New York state child support cases.
Yeah, of course, and that leads us right into our next question. What happens if the service member or veteran cannot afford the child support or if they fall into arrears?
Yeah, so this is probably the most common issue I assist veterans with. If you're dealing with this issue, I'd encourage you to call our helpline. Again, our number is 212-343-1122. It can be very challenging to change arrears, though sometimes the custodial parent will forgive some of them, or if the arrears are owed to New York City Department of Social Services, there are some debt forgiveness programs that could help lower them. So with arrears, though, it's important to determine that the amount is correct and then assess if there's any basis for an exception to also try to seek help from the court, where the rule is pretty strict that arrears that have accrued prior to the filing date of a modification petition cannot be adjusted. So oftentimes there will be no way to get rid of the arrears aside from paying them. I mean, just to speak about the court option real quick, it could be that if the amount is incorrect, the child support office might be able to help correct them, or you would need a court order to correct the amount. It could also be there's an uncommon avenue where you could maybe get the arrears capped if you're under the federal poverty level during the time period when they accrued. I've tried that. I haven't often been successful, but it works sometimes. So it's just be important to talk to an attorney about some of those options to see if there's any way to lower or get rid of the arrears if you owe them.
Yeah, absolutely. And like you said, please, if anyone on the live or any of your clients are going through or child support arrears, please reach out to our helpline. The number is there in the chat as well. That's 212-343-1122. But now we'd like to break again to see if there are any questions that have come up in the chat about child support, custody, or anything else that we have discussed so far this afternoon. We'll give it a minute, see if we get any questions. I think we've gone through all of the questions that were submitted beforehand, and thank you to everyone who did submit some questions. But if you have a question that hasn't been answered already, then please feel free to plug that into the chat.
Now, I will say, I think in terms of like what our office, at least what I've been able to help with in the past, has been involving service members and veterans. For service members, I get, getting the custody guardianship order in advance of enlistment. So helping set that up. A soon deployment where you need to modify your custody order in advance of that. On an emergency basis. I've also helped people where they are already deployed, but the parent who is with the child is essentially blocking them. Sometimes when a parent's far away and they're not able to be as involved, the parent at home can kind of disregard them more. And then with veterans, the most common issue is really these arrears, child support arrears, and so navigating that and making sure that they have they're getting the benefits that they're entitled to and that they need, and then figuring out how to help lower the arrears if possible.
All right. So if anyone has any questions, we will give it a minute, see if any come in. Otherwise, if you don't want to ask your question live, please feel free to reach out to our helpline. Again, that number is 212-343-1122. And as I mentioned earlier on, you can also access our website. You can also access our helpline via email and live chat on our website, which is familylegalcare.org. But we'll give it a minute and see if we get any questions.
So I see one. How is parentage or paternity established for active duty military members?
It would be largely the same way if they were not, or for civilian parents. Petition would be filed, and you would just have to navigate the Service Member Civil Relief Act protections, getting them served. Yeah, so a service member could possibly get a delay in the case until they get back. If a default order is entered, then it could be undone. So if you're filing for paternity, then you might have to revisit that later again.
Any other questions in the chat? No.
As a reminder, this will be available both on Instagram later on today. It will also get uploaded to our YouTube channel. We have multiple webinars available on our YouTube channel that cover everything from child support to family law basics, and you will be able to view those later if you want to go back to see anything you may have missed, or if you missed part of the presentation. It'll be available in full on our social media and on our YouTube page.
Thank you, Rihanna. And again, if you didn't get a chance to ask your question, please feel free to reach out to our helpline. That's 212-343-1122, or again on our website, familylegalcare.org. Thank you all again so much for joining us, for spending the afternoon with us. We hope that the session has been helpful. We thank all of the veterans and service members on the line for your service, and we wish you all a happy Veterans Day. Thank you, everyone.